Breaking! The U.S. legal system. Judge Cannon has dismissed the Florida documents case because she claims Jack Smith was illegally appointed as a special counsel. This is a completely bonkers, made-up decision that flies in the face of the Constitution, federal statutes, Supreme Court authority directly on point, and federal appeals court decisions that are also directly on point. It is a partisan decision that has no chance of being upheld by the 11th Circuit, but we live in a world where I have no idea what the Supreme Court would do if it takes this up. So who knows if in a year or two the Supreme Court might bless this and overrule 5 decades of precedent. But based on current law, this decision is nuts. But to understand that, you have to understand what is a special counsel. At base, this case is simply about whether there's statutory authority for attorney generals to appoint people to investigate and prosecute. And the answer is yes, there is authority, and attorneys general have been exercising it since the 19th century. Now, special or independent counsels have been around in one form or another for almost 150 years. President Ulysses S. Grant appointed the first independent counsel to investigate corruption in his administration, though he did fire that guy when he indicted Grant's personal secretary for defrauding the government. But Congress expanded that authority in 1966 when it passed 28 U.S.C. 533, which says that the Attorney General may, quote, appoint officials to detect and prosecute crimes against the United States. Now, after the fallout from Watergate, Congress passed the Ethics and Government Act in 1978, which authorized the appointment of independent counsels. And that act was used to investigate President Bill Clinton's Whitewater real estate deals, which eventually turned into an investigation over his affair with Monica Lewinsky. In 1999, the statute expired and Congress did not reauthorize it, in large part because many Congress members on both sides thought that Ken Starr's investigation was too independent and too far-ranging. And that illustrates the fundamental conflict with all these appointments, is that the special counsel needs to be independent enough from the executive to investigate and prosecute the executive, but not so independent that they run wild. But there was still a need for an independent investigative process, so in 1999, the Justice Department promulgated the rules governing the appointment of special counsels, relying on the Attorney General's general administrative hiring authority. And special counsels have served similar roles as independent counsels or special prosecutors. The Attorney General generally has the authority to appoint, supervise, and remove them, and that means that neither Congress nor the President can unilaterally fire a special counsel. And in the last 3 decades, there have been many special counsels on both sides of the aisle, including the Russia investigation led by Republican Robert Mueller, the investigation of Joe Biden for retaining government documents led by Republican Robert Hur, the investigation of whether Mueller was too mean to Trump led by Republican John Durham, and the investigation of Hunter Biden, which was led by Republican David Weiss. But it is odd that while the targets of the investigations have been on both sides of the aisle, the special counsel has almost always been Republican. But on November 18, 2022, Attorney General Merrick Garland issued an order appointing John Smith as special counsel after Donald Trump announced his candidacy for president. Smith's mandate was to investigate whether Trump unlawfully interfered with the 2020 presidential election and certification of the Electoral College vote, and whether Trump broke any laws when he removed classified documents and other presidential records from the White House to Mar-a-Lago. Now, much of Cannon's decision rests on who can appoint officers and inferior officers under the Constitution. So before we get further into this, here's the lay of the land when it comes to this particular legal question. Article 2, Section 2, Clause 2 of the Constitution is the Appointments Clause. It grants the President the, quote, power to appoint with the advice and consent of the Senate, ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. It goes on to say that, quote, Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments. So generally, some high officers, usually referred to as principal officers, in the executive branch must be appointed and confirmed by the Senate. This includes heads of departments like the Attorney General or the Secretary of State. Now, inferior officers can be appointed by the heads of departments, such as the Attorney General for the DOJ, so long as Congress has authorized the head of the department to make the appointment of that inferior officer. So in this case, if the special counsel is an inferior officer, then there just needs to be a statute authorizing the Attorney General to appoint them. If the special counsel were considered a principal officer, like a cabinet member, then they would need to be confirmed by the Senate. Now, for the most part, Judge Cannon assumed for the purposes of argument that the special counsel was some kind of inferior officer. So this whole question was whether Congress authorized the Attorney General to appoint the special counsel. Now, admittedly, there is also a controversy over whether the special counsel is even an inferior officer. They might just be a DOJ employee, which would circumvent all of this. But let's just ignore that for the moment. Now, there are many statutes which almost all lawyers and judges believe gives the Attorney General the right to appoint special counsels, especially 28 U.S.C. Section 515B, which states, quote, each attorney specially retained under authority of the Department of Justice shall be commissioned as a special assistant to the Attorney General or special attorney and shall take the oath required by law. Foreign counsel employed in special cases are not required to take the oath. the Attorney General shall fix the annual salary of a special assistant or special attorney. Yeah, so that sounds like it authorizes the AG to appoint special counsels to conduct legal proceedings. And then there's 28 U.S.C. 533. Quote, the Attorney General may appoint officials, 1, to detect and prosecute crimes against the United States, and 4, to conduct such other investigations regarding official matters under the control of the Department of Justice and the Department of State as may be directed by the Attorney General. Again, this is pretty direct authority for the Attorney General to appoint special counsels. And so far, every court that has looked at this has found that a special counsel was permitted. That includes at least 1 Supreme Court case, 5 federal courts of appeal, and 9 federal district court cases. And many of those have been penned by Republicans. Now, obviously, if you have a legal issue and don't have Judge Cannon in your pocket, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your social security number was leaked, were involved in a car crash, or are dealing with an immigration issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery and find out what your options are. So just click on the link in the description or call the number that's on screen right now for a free consultation with my team. Because you don't just need the legal team, you need the Eagle team. So the link is below. But Judge Cannon disregards all of that and found that the relevant statutes did not authorize Jack Smith's appointment. To do so, Cannon had to get around the Supreme Court's decision in the United States versus Nixon. Now, the unanimous court in U.S. versus Nixon held that, quote, under the authority of Article 2, Section 2, Congress has vested in the Attorney General the power to conduct the criminal litigation of the United States government, 28 U.S.C. 516. It also has vested in him the power to appoint subordinate officers and assist him in the discharge of his duties, 28 U.S.C. 509, 510, 515, 533. Acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to a special prosecutor with unique authority and tenure. The regulation gives the special prosecutor explicit power to contest the invocation of executive privilege in the process of seeking evidence deemed relevant to the performance of these specially designated duties. Now, that's about as on point as a Supreme Court case gets. The Supreme Court says that Congress has vested in the AG the power to appoint subordinate officers to act as special prosecutors. So why does Cannon disregard such precedent? Well, she dismissed that holding as dictum, something she doesn't have to follow because it was peripheral to the issues presented. Now, dicta or dictum singular is a part of a case that isn't binding because it isn't necessary for the outcome of the case, which just is not true here. If the court had felt that the issue went the other way, it would have invalidated the special prosecutor's subpoena and appointment in the U.S. versus Nixon. This was the case where Leon Jaworski, the special prosecutor, subpoenaed the Nixon tapes from the White House that ultimately led to Nixon's resignation from the White House. And even if this section of the case were dicta, it's pretty unusual for a district court not to follow the Supreme Court's dicta where it reflects a clear statement of law. And instead, she followed a concurrence by Justice Thomas in the recent immunity case Trump versus the United States. And ironically, she's following a concurrence which no other justice joined. And in that case, the Smith appointment wasn't even an issue in that case. But it appears that Thomas wanted to tee up that issue specifically for Cannon. Now, Thomas critiqued Nixon because he didn't like its analysis and he thought it was too short. Quote, if the court gave passing reference to the cited statutes as supporting the appointment of the special prosecutor in the United States versus Nixon, but it provided no analysis of those provisions' texts. So obviously Cannon treated Thomas's commentary, which no other justice joined, as if it was gospel rather than giving the Nixon case any weight. And similarly, Judge Cannon also disregards 2 appellate opinions in the D.C. Circuit, which are also directly on point. Cannon dismissed those as wrongly decided because they relied so extensively on the Nixon case, which she believes is wrongly decided. Quote, the Nixon dictum has taken on significance in related cases, and a full explication of the record is necessary. Now, those 2 D.C. Circuit cases are pretty illustrative. In the 1987 case, In Re Sealed Case, that dealt with the appointment of an independent counsel for the Iran-Contra scandal and found the appointment valid. The court held, quote, we have no difficulty concluding that the Attorney General possessed the statutory authority to create the Office of Independent Counsel Iran-Contra and to convey it to the investigative and prosecutorial functions and powers described in 28 CFR Section 600.1a of the regulation. While these provisions do not explicitly authorize the Attorney General to create an Office of Independent Counsel virtually free of ongoing supervision, we read them as accommodating the delegation at issue here. Now, that issue about supervision goes to a question about whether the old independent counsel was too independent, and we'll talk about that in a second. But the important thing here is that the D.C. Circuit specifically found that some of the exact same regulations gave the Attorney General authority to appoint an independent counsel. And then there is the 2019 case of In re grand jury investigation that dealt with the appointment of Robert Mueller, written by a Republican judge. There, the court held, quote, "Special counsel Mueller effectively serves at the pleasure of the executive branch officer who was appointed with the advice and consent of the Senate. The control thereby maintained means the special counsel is an inferior officer. Miller's contention that special counsel Mueller is a principal officer under the Appointments Clause thus fails." Oh, and that case also addressed the dicta question, quote, "In this analysis, the Attorney General's statutory authority to issue the regulations was a necessary antecedent to determining whether the regulations were valid and therefore was necessary to the decision that a justiciable controversy existed. The Supreme Court's quoted statement regarding the Attorney General's power to appoint subordinate officers is, therefore, not dictum." But Cannon rejects those questions, as well as the Supreme Court's Nixon case, on the basis that those cases did not analyze the wording of the underlying statutes, which is crazy. You'll note that all of those quotations cite to the statutes. Some are the exact same statutes at issue in this case. And when courts cite the statute, it means that it analyzed the statute and found that it supports the proposition that it's stating. So basically, she didn't follow those cases because they relied on Nixon, which she considers dictum, even though one of the cases explicitly says that Nixon was not dictum. And she did not believe that they analyzed the issue deeply enough, even though they analyzed the same statutes. Cannon then decides that a Scalia dissent in another Supreme Court case, Morrison versus Olson, was persuasive, which is odd because in that case, the Supreme Court actually held that Congress may grant authority to the judicial branch to appoint independent counsel without violating the separation of powers. In Morrison versus Olson, Chief Justice and Republican William Rehnquist, writing for a 7-1 court, held that an independent counsel was an inferior officer, largely because the counsel was subject to removal by a higher executive branch official. They had limited duties and had limited jurisdiction and tenure. And the court rejected Olson's argument that the act encroached upon the executive power since it allowed the Attorney General to remove independent counsel for good cause. Now, in that case, Scalia was the lone dissenter. He thought that the act violated the separation of powers by giving judicial officers the power to appoint and supervise executive officers, the special counsel. He believed that this infringed on the president's exclusive power to execute the laws. Now, this was in reference to the old independent counsel statute, where the counsel was appointed by a 3-judge panel rather than the attorney general. The idea was that the 3-judge panel would be insulated from politics. But that created potentially separation of powers issues because it was then the judicial branch creating executive branch officers. But even that was considered constitutionally sound according to the Supreme Court. And Scalia's dissent doesn't even apply to the appointment of Jack Smith because Smith was appointed and supervised by the Attorney General, not by the judicial branch. Now, in addition to disregarding binding authority from the Supreme Court for reasons, Cannon plays a bunch of linguistic tricks. Cannon analyzes Section 515, but says that the reference to a lawyer being retained does not mean it allows the Attorney General to appoint them. Now, her argument is that the word retained means that the special counsel must have already been appointed to the Department of Justice in the past and can't come from the outside. It's a distinction that appears to try to safeguard the special counsel in the Hunter Biden case, but still invalidate Jack Smith, since the Hunter Biden special counsel was already a standing United States attorney. But it would be silly for the statute to only allow for retaining someone already appointed, and the statute clearly contemplates retaining them for the first time pursuant to that statute. Not to mention the statute requires them to take an oath, which they already would have done if they had been previously appointed as an inferior or principal officer of the United States. Not to mention, this is the process of how special counsels, independent counsels, and special prosecutors have been selected for decades. In fact, Leon Jaworski, the special prosecutor in U.S. versus Nixon, was chosen from outside of the Department of Justice, just like Jack Smith was. But Cannon writes that, quote, "Mr. Smith is a private citizen exercising the full power of a United States attorney and with very little oversight or supervision." But that's completely wrong. First of all, the special counsel doesn't have nearly the same scope of authority as a U.S. attorney. And second of all, the special counsel is bound by all of the same rules of the Department of Justice and is supervised by the Attorney General. Further, according to Cannon, Smith and special counsels are not an official, which is the word used in Section 533. Section 533 allows the Attorney General to appoint officials. Cannon goes to great convulsions to show that officer and official are incredibly different words with very different meanings. And to come to that conclusion, she doesn't use any kind of legal authority. She uses a handful of cherry-picked, out-of-date dictionary definitions. Now, I'll spare you that analysis because it's nonsense, but for over 50 years, the Supreme Court and like 13 other courts have made it clear that official includes officers. Further, she writes that, quote, Section 533's use of the phrase detect and prosecute crimes does not otherwise transform the provision into a grant of special counsel appointing authority. Here she concludes that this section of the statute is only about FBI employees and doesn't relate at all to other law enforcement personnel, such as lawyers who work at the Department of Justice, which is just anti-textualist. That's not what the law says. It's also extremely weird because the FBI does not and cannot prosecute anyone. That's the job of the assistant U.S. attorneys. So this section literally cannot only refer to the FBI. Finally, in one of the last sections of Cannon's decision, she suggests that Jack Smith is too independent to be considered even an inferior officer, and it might be the case that the special counsel is a principal officer, like the Attorney General himself, which would require Senate approval no matter what. But ultimately, she just throws her hands up and says it's complicated and that a higher court should make that call. Quote, after examining the broad language in the Supreme Court cases on the subject and seeing a mixed picture, even if a compelling one in favor of principal designation, the court elects with reservations to reject the principal officer's submission and to leave the matter for review by higher courts. Hey, it's important to know your own limitations as a jurist. And additionally, Judge Cannon also found that Smith's funding was unlawful for the same reasons the appointment was unconstitutional, that she claims there wasn't a statute that covered it. But that argument is simply duplicative of all the other statutory misinterpretations she does earlier in the decision. Peter Carr, the spokesman for Smith, issued a statement, quote, the dismissal of the case deviates from the uniform conclusion of all previous courts to have considered the issue that the Attorney General is statutorily authorized to appoint special counsel. The Justice Department has authorized the special counsel to appeal the court's order. Now, it's likely that Smith has been looking for a way to appeal Cannon's orders and perhaps to get her removed from the case for quite some time, but until now, Cannon has avoided deciding a legal issue that would be reviewable by the 11th Circuit. But her removal from the case is far from a sure thing. The 11th Circuit will only remove Cannon if there is clear evidence of bias, and that legal standard is very tough to meet. The two disqualification statutes are 28 U.S.C. 455 and 28 U.S.C. 144, and to disqualify Cannon for personal bias, Smith would have to show the bias or prejudice was personal and from an extrajudicial source, and the fact that Trump appointed Cannon is irrelevant to this determination. The 11th Circuit has rebuked Cannon before, but by grounding part of her decision in Justice Thomas's interpretation of the special counsel, it has a fig leaf of legitimacy. But in any event, Smith's appeal won't be decided anytime soon. If the 11th Circuit reverses, then the Supreme Court will get a crack at it, which puts this well into 2025. And in theory, Smith or Attorney General Garland could refile the case using a U.S. attorney, though that would be ironic because they would be under the more direct supervision of the Attorney General, which appointing a special counsel was meant to avoid, so they would be politically insulated. But if things are refiled instead of going through the appellate process, there are questions of whether that might reset the investigation and prosecution back to 2022. Now, if you enjoyed this analysis, I go into more detail in the version that's available on today's sponsor, Nebula. On Nebula, you can always watch my videos ad-free and early because my videos always go up on Nebula first. And for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest deal of all. Plus, there's tons of exclusive content. For example, we just released an exclusive reaction to the military law movie Rules of Engagement, and that one will never be on YouTube because it's about some really unsavory crimes and Marines. And for every upload that I do, I always try to provide just a little bit more insight into the topics and analysis for the version that goes up on Nebula. And I know tens of thousands of you signed up for Nebula using the CuriosityStream bundle, but unfortunately that's over. CuriosityStream has informed us, and even included in their latest SEC filing, that they don't intend to pay us bundle revenue in 2024. That means that I and my fellow Nebula creators won't get any money from bundle subscribers. So the bundle is breaking and you're not going to be able to have access to Nebula anymore after 2024. So if you want to support me and this channel, the only way to ensure that that money that you spend on Nebula actually goes to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. With your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and of course, LegalEagle. And the exclusives on Nebula are getting really good. We have a whole slate of exciting projects this year. Right now, I'm really enjoying Jetlag The Getaway. It involves some of my absolute favorite people doing some crazy travel-related challenges, but it's all rigged in a way that basically they're playing Secret Hitler, but everyone is Hitler. It's really, really hilarious. And of course, you can always watch my other Nebula exclusive content like my feature-length documentary Bad Law Words Good, my full-length interview with the screenwriter of My Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters. And because it's a subscription service, we get to work on larger, higher budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything Nebula has to offer with your friends and family, Nebula also offers annual gift cards. So if you sign up using the link that's on screen right now or down in the description, you can give a year of Nebula to a friend for 40% off the yearly subscription. And that friend can be you if you want. So you can get a 40% off discount for you or a friend's yearly subscription, or you can check out Lifetime, where for $300 you can get access to Nebula forever, and with your purchase going to fund creation of even more exciting originals than ever before. In a way, Lifetime is the best possible deal of all. Either way, you'll get all my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on for our own streaming site. So sign up now and get you or a friend 40% off of Nebula, or get the incredible Lifetime deal by clicking on the link below. And after that, click on this box over here for more LegalEagle, or I'll see you in court. When President Donald Trump targeted law firms with executive orders, some fought back and some bent the knee. And I took that personally. Those who capitulated looked like fools, and as a bonus, they are also losing clients. Now, everyone already hated firms like Skadden and Kirkland & Ellis, but some got really taken for a ride. Case in point, the law firm of Simpson and Thatcher, which agreed to perform $125 million in free legal work for causes acceptable to the Trump administration. And shortly after Simpson and Thatcher bent the knee, one of their huge clients, Microsoft, dumped them. The firm was working on a massive case related to the company's acquisition of Activision Blizzard, but Microsoft dumped them and hired the firm of Jenner Block, a firm that actually stood up to Trump's executive orders. Now, as we predicted and opined on this channel, the law firms who responded with, "We'll fight you in court," are looking pretty good, but now they've been justified. Federal District Court Judge Beryl Howell in D.C. has now ruled that Trump's executive order targeting Perkins Coie was unconstitutional, rendering the order now null and void. And the judge's order is scathing. Judge Howell issued a permanent injunction blocking the executive order in its entirety, and she started off by saying, quote, "No American president has ever before issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies, but in purpose and effect, this action draws from a playbook as old as Shakespeare, who penned the phrase, 'The first thing we do, let's kill all the lawyers,' William Shakespeare, Henry VI. When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates his tactic as part of his plan to assume power, leading in the same scene to the rebel leader demanding 'away with him,' referring to an educated clerk who can make obligations and write court hand. Eliminating lawyers as the guardians of the rule of law removes a major impediment to the path to more power. See Walters versus National Association of Radiation Survivors, explaining the import of the same Shakespearean statement to be that disposing of lawyers is a step in the direction of a totalitarian form of government. The importance of independent lawyers to ensuring the American judicial system's fair and impartial administration of justice has been recognized in this country since its founding era. In 1770, John Adams made the singularly unpopular decision to represent 8 British soldiers charged with murder for the roles in the Boston Massacre, and claimed later to have suffered the loss of more than half his practice. "I had no hesitation," he explained, "since counsel ought to be the very last thing that an accused person should want in a free country, and the bar ought to be independent and impartial at all times and in every circumstance." The instant case presents an unprecedented attack on these founding principles. By its term, this order stigmatizes and penalizes a particular law firm and its employees, from its partners to its associate attorneys, secretaries, and mailroom attendants, due to the firm's representation, both in the past and currently, of clients pursuing claims and taking positions with which the current president disagrees, as well as the firm's own speech. In a cringeworthy twist on the theatrical phrase, "Let's kill all the lawyers," EO 14230 takes the approach of "let's kill all the lawyers I don't like," sending the clear message, lawyers must stick to the party line or else. Now, in a footnote, Judge Howell addresses law firms like Simpson Thatcher, Kirkland & Ellis, and Skadden Arps. Quote, "This message has been heard and heeded by some targeted law firms, as reflected in their choice, after reportedly direct dealings with the current White House, to agree to demand terms, perhaps viewing this choice as the best alternative for their clients and employees. Yet some clients may harbor reservations about the implications of such deals for the vigorous and zealous representation to which they are entitled from ethically responsible counsel, since at least the publicized deal terms appear only to forestall rather than eliminate the threat of being targeted in an executive order. Only when lawyers make the choice to challenge rather than back down when confronted with government actions raising non-trivial constitutional issues can a case be brought to court for judicial review of the legal merits, as was done in this case by plaintiff Perkins Coie LLP, plaintiff's counsel Williams and Connolly, and the lawyers' firms, organizations, and individuals who submitted amicus briefs in this case. As one amicus put it, "Our judicial system is under serious threat when determining whether to file an amicus brief could be a career-ending decision. But when lawyers are apprehensive about retribution simply for filing a brief adverse to the government, there is no other choice but to do so. If the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and, by doing so, serve to promote the rule of law will be the models lauded when this period of American history is written. Now, if you're illegally targeting some of the most powerful law firms in the country, you're going to want a good lawyer. Not any of those law firms that capitulated right out of the gate. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've got in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's absolutely nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, if you've been watching this channel recently, then you'll know that I, along with over 500 different law firms, signed an amicus brief in support of Perkins Coie. And the amicus brief that Judge Howell just cited is a different amicus brief, but I wholeheartedly join in the sentiments of the Pickering law firm in that particular brief. That brief was filed by a Massachusetts solo practitioner who, on his own, decided to stand up to Trump on behalf of his fellow lawyers. And the contrast between Kenneth C. Pickering and firms like Paul Weiss and Simpson Thatcher could not be more stark. And turning to the First Amendment, Judge Howell wrote, quote, "One obvious implication of these First Amendment protections is that government officials may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. This prohibition also extends to retaliation against individuals for the specific viewpoint expressed by the First Amendment protected activities. Since the government may not use the power of the state to punish or suppress disfavored expression, nor use threats of legal sanctions and other means of coercion to achieve the suppression of disfavored speech, retaliation and threats of retaliation to effectuate viewpoint discrimination is uniquely harmful to a free and democratic society. To prevail on these claims, plaintiffs must show that the firm engaged in conduct protected under the First Amendment, 2, that EO 14230 took some retaliatory action sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again, and 3, that there is a causal link between the protected First Amendment activity and the adverse action taken against the firm." And the judge ruled that plaintiffs easily satisfied these requirements. Quote, "Here, no genuine dispute of material fact exists as to any of these 3 elements, and thus plaintiff is entitled to summary judgment on counts 5 and 7. EO 14230 openly acknowledges the plaintiff engaged in speech and other activities protected by the First Amendment. Section 1 of the order, which sets out its purpose, cites 3 reasons for the enumerated action items in sections 2 through 5 that federal agencies are ordered to take against plaintiff. 1, the firm's representation of Hillary Clinton during the 2016 presidential election. 2, the firm's involvement in litigation against election laws, including those requiring voter identification, and 3, the firm's alleged discrimination in hiring and promotion and efforts to purposefully hide the nature of this alleged discrimination through deceiving language. The associated fact sheet adds a 4th. Perkins Coie LLP has filed lawsuits against the Trump administration, which are also described as partisan lawsuits against the United States. Judge Howell ruled that President Trump's intent to retaliate against Perkins Coie because of its political views was obvious. Quote, "The first, second, and 4th reasons reference the firm's representation of clients, namely President Trump's opponent in the 2016 presidential election, parties in election litigation, and parties challenging Trump administration actions. Well-settled law establishes that advocacy by attorneys to the courts falls within the category of private speech protected by the First Amendment, meaning that plaintiff's representation of a political opponent of the current president and involvement in election litigation and lawsuits against the Trump administration explicitly qualifies as core First Amendment speech." Now, the Trump administration also claimed that law firms which champion diversity are breaking the law. As for the claim that Perkins engaged in unlawful employment practices, Judge Howell noted it's not illegal to hire black lawyers and female lawyers. She saw the government's assertion for what they are. Quote, "The government's briefing reveals the true motivation lurking behind the facade of discrimination allegations, the administration's disapproval of plaintiff speech in favor of diversity. This revelation makes clear the pretextual nature of EO 14230's cited reason regarding plaintiff's reported discrimination. For instance, the government points to the firm's statements about efforts to contribute to the advancement of our historically underrepresented attorneys and success in hiring new partners who are women or attorneys of color. Once again, however, the government provides no evidence to suggest that any of these statements show any suspect or illegal actions by plaintiff. Even more probative of the fact that plaintiff's speech is at issue is that the government argues that statements in the amended complaint repeatedly asserting plaintiff's commitment to diversity and showing no apparent intention of backing away somehow support the government's actions targeting the firm in the order. These 4 reasons are the sole rationales provided for in the issuance of EO 14230, and each, on their face, implicate First Amendment protected activities. Now, the judge also found that the executive order was enough to chill speech. Quote, "The second requirement for a retaliation claim that plaintiffs show the actions taken against the firm were sufficient sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again, is satisfied by plaintiff's showing of irreparable harm and further bolstered by the reactions of plaintiff's peer law firms. The fact that Paul Weiss quickly negotiated a deal, including an agreement to provide the equivalent of $40 million in free legal work rather than face the potential injuries of this similar executive order targeting that firm, demonstrates the coercive power of such targeting by the Trump administration. This conclusion is further confirmed by the reaction of additional peer law firms that chose to negotiate deals with the Trump White House to avoid being targeted by similar executive orders. Now, President Trump claimed his executive orders were meant to protect the public interest, but Judge Howell found, quote, EO 14230, the accompanying fact sheet, and the context surrounding the order's issuance each express President Trump's disapproval of plaintiff's First Amendment activity and demonstrate that EO 14230 targeted plaintiff because the firm expressed support for employment policies the president does not like, represented clients the president does not like, represented clients seeking litigation results the president does not like, and represented clients challenging some of the president's actions, which he also does not like. This is unconstitutional retaliation and viewpoint discrimination, plain and simple. Plaintiff is therefore entitled to summary judgment on counts 5 and 7. And Judge Howell also explained the vagueness of the government's attack on diversity, equity, and inclusion. Quote, the order goes on to mention the administration's goal of ending discrimination under diversity, equity, and inclusion policies, leading to a possible inference that such policies and not any concrete evidence of discrimination are the problematic conduct that the plaintiff should avoid. The terms diversity, equity, and inclusion, taken collectively or individually, however, could refer to a wide range of actions and programs, formal or informal, as well as basic thoughts and beliefs. The order provides no definition or guidance as to what form of program possibly described by these terms is considered unlawful discrimination by the Trump administration, leaving plaintiff to guess at what is and is not permissible in the government's view, while already facing the threat of adverse actions during the guessing. The government's own briefing reflects this uncertainty. While repeatedly accusing the plaintiff of engaging in racial discrimination, the government at various times also state that 1, plaintiff should be investigated by the EEOC to determine whether they are violating the civil rights laws. 2, the government is merely trying to advance valid social policies regarding discrimination rather than enforcing any legal prohibitions. 3, diversity initiatives are legally suspect and thus plaintiff's practices provide ample basis for review. 4, the government is merely raising legitimate legal issues of just how far DEI policies and programs can go and whether such policies cross the line into illegal discrimination. 5, plaintiff engaged in aggressive DEI practices. And 6, plaintiff appears to have engaged in what the government characterizes as discrimination. When even the government cannot decide what exactly the grounds for its actions were, plaintiff is truly left unable to know what conduct to avoid. On top of that, in a topic that may only be interesting to legal weirdos like myself, Judge Howell did not get into the issue of whether the executive order qualified as a bill of attainder, but she made it very clear that had she gotten to that issue, she would have found that it was a bill of attainder, and specifically against one particular entity, in this case, the law firm. So at the end, the judge therefore concluded, quote, the U.S. Constitution affords critical protections against executive action like that ordered in EO 14230. Government officials, including the president, may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. They may neither use the power of the state to punish or suppress disfavored expression, nor engage in the use of purely personal and arbitrary power. In this case, these and other foundational protections were violated by EO 14230. On that basis, this court has found that EO 14230 violates the Constitution and is thus null and void. For the reasons explained, plaintiff is entitled to summary judgment and declaratory and permanent injunctive relief on counts 2 through 9 of the amended complaint. The government's motion to dismiss is denied. Now, it's possible this might go up on appeal, though this administration has shown that sometimes when they lose the really obvious cases like this one, they don't even bother to appeal it, so that's also a possibility here. But this case is now ripe for appeal if the government so chooses, and if they do, they're gonna lose again because this is unbelievably illegal conduct. And the lesson here is that lawyers and law firms simply cannot capitulate to a person who says he isn't sure if presidents have to uphold the Constitution. Now, as legal cases go, this was a very, very easy decision. And that makes it particularly interesting to see how the media has covered Judge Howell's ruling. Over 190 outlets reported on it, with about 60% coming from the center, 25% from the left, and only 15% coming from the right. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. Of the few right-leaning sources that picked it up, most headlines referred to Judge Beryl Howell as an Obama judge and characterized her quotation of Shakespeare in a mocking tone. From the left, a common theme was to emphasize that Trump's executive order was ruled unconstitutional, with one source even calling it cringeworthy. Then from the center, sources were most likely to use the word block instead of harsher phrases like strike down. But the headlines you read first have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. Now, this can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like the related story of DC power attorney Abby Lowell launching a law firm to specialize in defending public officials and others targeted by the Trump administration. And in fact, he's actually hired a bunch of the lawyers who left the firms that did capitulate. Now, this story was largely ignored by right-leaning media, representing only about 10% of the source's reporting. And this type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what to others seems like nonsense or fake news. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more LegalEagle, or I'll see you in court. The Supreme Court smacked down the Trump administration's efforts to summarily cut off aid around the world. Hooray! The Supreme Court decided that Congress still matters. And that's great. The celebration by most commentators is warranted. But I'm sorry to tell you there are some very, very dark clouds lurking in the background. And this decision's tepid defense of the rule of law could spell disaster in the future. In a very brief 5-4 unsigned opinion, the Supreme Court upheld the lower court's order for the administration to pay out on its debts. Yes, if you're keeping score at home, that's 4 votes in favor of basically dictatorship. But at least Justice Amy Coney Barrett sided with Justice Roberts and the liberals in defense of the law, I guess, which caused all kinds of right-wing infighting, so that's nice. But it may be too early to celebrate because the Supreme Court's willingness to even consider overruling a lower court's temporary restraining order was itself a strange and ominous sign. And more troublingly, 4 members of the Supreme Court signaled that they didn't think the courts even have the authority to consider this case because this case is a violation of sovereign immunity. But what does this all mean, and how did we get here? Well, a week ago, we talked about the AIDS Vaccine Advocacy Coalition versus the Department of State case, but that feels like a lifetime ago, so let's do a quick refresher to delve into the aspects of this case. On January 20th, 2025, President Trump issued an executive order titled Reevaluating and Realigning United States Foreign Aid, which directed an immediate freeze in United States foreign development assistance. This halted a broad array of foreign aid programs, many of which were life-saving campaigns aimed at alleviating hunger and providing essential medical care. OMB then issued a memorandum detailing instructions for the fulfillment of Trump's executive orders on grant programs, including the Foreign Aid Executive Order. In its memorandum, OMB ordered other agencies to pause the disbursement of all federal financial assistance, including foreign aid. Soon afterward, 2 separate courts issued orders forbidding the Trump administration from continuing this funding freeze. The administration took that court order under advisement and continued to do what it wanted to do, withholding funding on a wide variety of grants, contracts, and awards, including 800 USAID awards and contracts. The administration conducted these funding freezes with its usual level of incompetence. One of the plaintiffs in this case noted it received, quote, a flurry of stop work orders, often without any indication of what awards they were in reference to. The stop work orders contained vague and contradictory statements. Some letters indicated the award was being terminated because it no longer effectuated agency priorities. Others claim that the award termination wasn't because of any actions of the organization and was instead being ordered so that the new administration could have time to review the awards. Chaos ensued. Organizations around the world were forced to shut their offices, lay off their staff, and turn away people the United States had pledged to help. Millions of people around the world were affected, and humanitarian operations for refugees in places like Syria were abruptly stopped. Soup kitchens in Khartoum were closed, and clinical trials for life-saving children's tuberculosis treatments in Uganda were halted. So on February 10th, a lawsuit was filed for a variety of aid organizations, including an AIDS research organization, an organization that promotes journalism about corruption-related issues, an organization that protects refugees and asylum seekers, and an organization representing small businesses in this sector. These organizations laid out a list of heart-wrenching harms in their filings and pleaded for a temporary restraining order from the court. And as we've talked about, this is an unusual and challenging ask. Now, lately we've spent a lot of time talking about temporary restraining orders, or TROs. And that is weird because TROs are an extraordinary remedy. and only appropriate in cases where the imminent harm justifies immediate court action and the loosening of usual procedural requirements. So it's remarkable that so many TROs have been granted against the Trump administration, and all in less than 2 months. And in the AIDS Vaccine Advocacy Coalition case, the plaintiffs argued that a TRO was warranted, though, because the plaintiffs are likely to succeed on the merits of the case, there's irreparable harm, the balance of the equities tips in their favor, and the injunction is in the public interest. And plaintiffs managed to make their case on all counts to Judge Ali in the D.C. District Court. In their filings and in hearings, the plaintiffs laid out a long list of irreparable harms, including the disruption of clinical trials for HIV prevention medication, the shuttering of program offices that protect refugees and asylees, the closure of small businesses that provide aid, the disruption of maternal and child health programs, the end of medical services for adolescents and students, and a freeze on time-sensitive anti-malaria campaigns. And the administration's attorneys were, at least, willing to concede that this parade of horribles contained irreparable harms. They argued, though, that the plaintiffs were unlikely to succeed on the merits of the case. The court disagreed, finding that the plaintiffs were likely to succeed on the merits, and the court agreed that a blanket freeze on all contracts was likely a violation of the Administrative Procedure Act because it was arbitrary and capricious, stating that, quote, there has been no explanation offered in the record, let alone a satisfactory explanation, including a rational connection between the facts found and the choice made, as to why reviewing programs, many long-standing and taking place pursuant to contractual terms, required an immediate and wholesale suspension of appropriated foreign aid. The defendants, for their part, tried to claim that this wasn't actually an agency action, it was a presidential action and was thus not subject to the Administrative Procedure Act, which governs agency actions. But the court wasn't buying it, finding that the defendant's argument, quote, would allow the president and agencies to simply reframe agency action as orders or directives originating from the president to avoid APA review. And that makes perfect sense because on some level, all directives come from the president, and if that's all it takes to avoid the APA is meaningless. But Judge Ali declined to give the plaintiffs the full relief that they were asking for, choosing instead to grant a narrow order which temporarily enjoined the government from freezing funds or issuing stop work orders on programs that were already in existence as of January 19, 2025. The court, however, allowed the government to stop funding for individual contracts if it was part of enforcing the pre-existing terms of their contracts, including expirations, modifications, and terminations. And the administration took full advantage of that loophole. Now, if you're going to disregard the order of a federal court judge, you'll want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can help represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. In the government's February 18th briefing, the defendants unabashedly stated that, quote, thus far that analysis has confirmed that at least substantially all of the terminations, suspensions, and stop work orders issued on USAID contracts, grants, and cooperative agreements were allowed by the terms of those instruments or terms implicitly incorporated into those instruments. That was not only wrong, but it would have been impossible for them to make that determination on hundreds or thousands of contracts in that time frame. So in response to the revelation the defendants were still effectively freezing nearly all funding, the plaintiffs filed a motion for contempt. The court was apparently unimpressed with the defendants' failure to comply. Judge Ali declined to find the defendants in contempt, but he did reiterate that the defendants needed to end the blanket freeze on funding. But for some reason, this was still not clear enough direction for the defendants, who asked the court to clarify its order. On February 22nd, Judge Ali replied to defendants' motion for clarification, stating that, quote, the line here is unambiguous. Defendants cannot continue to suspend programs or disbursements based on the blanket suspension that was temporarily enjoined. And defendants cannot simply come up with a new post hoc rationalization in an attempt to justify the action that was temporarily enjoined and is likely arbitrary and capricious for what it failed to consider. Judge Ali reiterated that particular contracts could be paused, but only if there was an individual evaluation of that specific contract. A blanket freeze, however, would be a violation of his order. And to underscore his point that he'd already been clear enough, Judge Ali quoted from his own prior order. And defendants, intent on continuing the blanket freeze on life-saving congressionally appropriated foreign aid funds, filed an interlocutory appeal to the D.C. Circuit Court and asked Judge Ali to stay his order in the meantime, complaining the, quote, court's order requires defendants to disburse nearly $2 billion by 11:59 p.m. tomorrow. And Judge Ali, who was apparently very good at suffering fools, denied the motion for a stay and reminded the defendants he'd already granted them a fair amount of flexibility, and it appears as though they haven't done anything to comply with his order. He was unmoved by the defendants' arguments that they hadn't had enough time to comply, pointing out that they had never actually asked for more time, and after reciting a laundry list of insufficiencies in the defendants' arguments, he denied the motion for a stay pending their appeal. But that appeal itself is also procedurally weird. Now, fun fact about TROs, they usually aren't appealable. That's because they are extraordinary and temporary relief. But the defendants tried a sleight of hand. They claimed they weren't appealing the judge's TRO itself, they were appealing his subsequent orders to enforce the TRO. Well, the Court of Appeals could not be tricked. In a very brief 2-page ruling, Judges Pillard, Penn, and Garcia held that TROs generally aren't appealable, and neither are any later issued orders seeking to enforce an unappealable TRO. And so the defendants, still intent on withholding life-saving congressionally appropriated foreign aid, appealed their case to the Supreme Court of the United States, asking the court to vacate Judge Ali's order. Now, this was also a procedural anomaly because, again, TROs are usually not appealable. So all the Supreme Court needed to do here, and arguably should have done here, was nothing. Nothing would have been the ordinary thing to do. Instead, on February 26th, the Supreme Court took the extraordinary step of granting the defendants a stay so the Supreme Court could consider the case. Now, if you go to McDonald's and ask for a tire change, the answer should not be, "We'll think about it." But that's what happened here. Then, on March 5th, the court issued a 1-paragraph decision holding that because the deadline for the original TRO had passed, and because the parties are in the midst of briefing for a preliminary injunction in the district court, the stay would be vacated. In other words, that the original TRO would be in effect. But the court also instructed Judge Ali to, quote, clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. Now, let's be clear, this was a victory for the plaintiffs. The TRO will go into effect in some respect. But the TRO had already been on the books for 3 weeks, and the government had done nothing to comply. And the court had issued 4 different orders ordering enforcement of the TRO. So it's not a great sign that the Supreme Court said, issue yet another order, but be more favorable to the government this time. But worse, that very brief ruling was followed by a fiery 7-page dissent authored by Justice Alito, joined by Justices Thomas, Gorsuch, and Kavanaugh. Now, by definition, a dissent does not carry the force of law, but what's in this dissent has a lot of bad signs for the rule of law. In a memorable opening salvo, Justice Alito wrote, quote, does a single district court judge who likely lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. I mean, technically, yes, that is one way that you can summarize a court forcing the government to comply with the Article 1 and Article 3 obligations of the Constitution. It's a summary that belongs more on Fox News than in the pages of something issued from the Supreme Court, but here we are. Alito referred to Judge Ali's order as a lawless act of judicial hubris and said that Judge Ali had wrongly brushed aside and shrugged off the government's argument that sovereign immunity barred this enforcement order. He argued that by undoing the stay, the majority of the court had abrogated its duty to ensure that the power entrusted to federal judges by the Constitution is not abused. And in what is likely to be a common theme throughout the next 4 years, Justice Alito bemoaned the nationwide injunction in this context, though he loves it when it comes to restricting anything related to abortion. And Justice Alito argued that a TRO wasn't the right mechanism for all this, where vast sums of money would, as he put it, probably be lost forever. Weird way to say that the government is spending money on something it chose to spend its money on. But instead, the DC District Court ought to have taken the steps to order a preliminary injunction, which is an appealable order. The Court of Appeals should have vacated the District Court's, quote, erroneous order. Justice Alito also disagreed strongly with Judge Ali about which party was likely to prevail on the merits of this case. Alito wrote that the government would likely succeed in its argument that sovereign immunity deprives the district court of having jurisdiction over this matter at all, because sovereign immunity generally bars monetary suits against the government. Now, because the majority's response was so brief, they didn't delve into any of this, but there's good reason to believe that Justice Alito was mistaken on this point. Alito is correct that generally sovereign immunity bars lawsuits against the government. In particular, there's case law that bars monetary suits, but the government can waive that immunity, and it has done so in the Administrative Procedure Act, which expressly allows plaintiffs to sue the government for monetary relief. Alito argues that even the APA's waiver doesn't apply here because the relief Judge Ali granted would result in the government paying out billions of dollars. But Alito is confusing the plaintiff's request that the court order the government to honor its contracts with a demand for monetary damages. The plaintiffs in this case are not asking for monetary damages, and Judge Ali did not grant them in the traditional sense. Instead, he said the money at issue would be paid out as the natural result of the ordered action, the unfreezing of the contracts. That's an important distinction and would fit under the APA's waiver, allowing plaintiffs to file suit and seek unfreezing of the contracts. It's also important to note, as Judge Ali did after the case had been appealed, that defendants didn't really argue the sovereign immunity angle in their earlier filings. Alito is arguing it for them, but it was never really briefed on the district court level. Still, Judge Ali pointed out that he didn't think that this would be a strong argument or change his opinion about the plaintiff's likelihood to succeed on the merits. Alito also argued the district court's remedy was too broad because it had ordered the government to honor all of its contracts, not just the contracts it had with the plaintiffs. Now, it's impossible to know what the majority would think about this because it wasn't included in their 1-paragraph opinion, But plaintiffs point out in their own briefings that what they were asking wasn't overbroad. What they demanded was merely the restoration of the status quo in which the United States government honored its contractual obligations. And this is the real crux of the case. If the government wanted to conduct an audit of all of its contracts, there's a way to do that. They could have reviewed each contract and then ended the ones that showed signs of fraud or abuse. That's what would have happened in a normal world. Instead, they put a blanket freeze on all contracts, ostensibly so they could conduct a review, but that's a review that they didn't or weren't conducting. And that's an extraordinary action that justifies Judge Ali's grant of extraordinary relief. But Justice Alito concluded his dissent with a parting shot at the, quote, self-aggrandizement of the district court and Judge Ali's hubris in ordering the Trump administration to pay out on government contracts. Justice Alito sees a constitutional crisis in the situation, and plaintiffs also see a constitutional crisis, but they're clearly seeing different crises. Now, where plaintiffs believe this is a question of separation of powers between Congress and the president, Justice Alito instead believes that this is a question of separation of powers between a lowly district court judge and the president. Now, we've discussed this before. The president doesn't have the authority to direct the disbursement of taxpayer funds. Article 1 of the Constitution, only Congress has that authority. And Congress has already designated these funds for foreign aid. For the president to step in and overrule Congress's spending choices, that's an extraordinary overstep and a violation of basic separation of powers. Now, we pointed out that the separation of powers issues will put this country into a constitutional crisis, but we might need to make that constitutional crisis plural because there are multiple constitutional issues here. First, as we've mentioned before, will the president obey the order to unfreeze the funds? And second, if this case does return to the Supreme Court, will that court recognize that only Congress has the power to pass laws and appropriate funds? Or will the court instead allow the president to unilaterally overrule Congress's spending decisions? And the Trump administration's track record in this case, repeatedly ignoring Judge Ali's orders, should raise some major red flags. And the Supreme Court's choice to issue a ruling at all in this matter should probably raise some yellow ones, because as noted earlier, TROs are usually unappealable. Now, it could have been worse, of course, if the court had outright said that TROs are now appealable for the Trump administration, or if a fifth justice had agreed with Justice Alito's blistering analysis. It could have been worse might be the best that we can hope for in the current moment. But I'd argue this decision is not a cause for celebration, because there were 4 justices in the dissent who said outright that they didn't think that any court has jurisdiction over the case because the government has sovereign immunity, even when the government fails to pay out on billions of dollars of contracts. That signals that those 4 justices are likely to allow the Trump administration to get away with even more legally dubious actions, because those justices believe strongly in executive power, perhaps absolute executive power, and think that the job of the court isn't to restrain an out-of-control monarchical president. It's hard to overstate how important this is. If the court says that sovereign immunity prevents anyone from suing over the executive's refusal to honor congressionally appropriated funds, then Congress can pass whatever laws it wants to, but the executive can just refuse to enforce those laws. And it only takes 4 justices to grant certiorari on a case to allow a case to be heard in the Supreme Court, which Justice Alito clearly invited the defendants to ask for here when he stated that the majority should, quote, at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. But for now, the case has returned to Judge Ali in the DC District Court. On March 6, Judge Ali held a status conference for the parties. The parties each reiterated their arguments, and the plaintiffs pointed out the extent and cost of the defendants' noncompliance with the court's order, including the government's apparent invention of new bureaucratic hurdles to obtain the promised funds. Plaintiffs argue that defendants' own declarations make it clear the administration has added new layers of bureaucracy to prevent the review process, requiring political appointees to sign off on each individual payment and confirm that the payment isn't only valid, but is also in line with the president's policy priorities. Plaintiffs also argue that despite the court's order to halt stop work orders, the defendants have continued to terminate contracts en masse. Some contracts have been reinstated, but the process and guidelines for reinstatement are predictably chaotic and disorganized. Plaintiffs laid out a proposed schedule for the government to pay out on its contractual obligations. Defendants claim that they are actually already in compliance with the court orders. They argued that they had continued to individually assess contracts and that no contracts are in a paused state because they have all either been retained or terminated. Defendants assured the court that they had reviewed the plaintiffs' contracts and are in the process of making payments to plaintiffs, and they argued that therefore the plaintiffs' challenge to the executive order's pause on payments is now moot. But the plaintiffs disputed the assertion that the payments owed to them have been satisfied, and the court has yet to rule on these warring factual accounts. But it's very likely that if the court rules that the government's actions still haven't fulfilled their obligations, there will be a speedy appeal by the Trump administration, which will eventually end up back at the Supreme Court where, best case scenario for the plaintiffs and possibly democracy, a razor-thin majority will uphold the requirement that the United States make good on paying its debts. And at the scheduled hearing, Judge Ali apparently ordered the government to pay up by Monday at 6 p.m., which might be the day that you're watching this. So I also look forward to finding out what the government does just as much as you do. And at the same time this happened, hundreds of diplomats joined together in a letter to Marco Rubio protesting the dismantling of USAID. And when you look at the headlines, you see very different frames emerge that shape how readers interpret and understand the events that are unfolding. On the right, we see headlines claiming that, quote, "We may all regret dismantling USAID, mostly because it undermines US leadership and security." On the center, a common theme is to signal boost the letter's central argument that USAID is, quote, "one of the most efficient, effective agencies." And on the left, headlines typically focus on the consequences to those who rely on the aid, like the millions of people suffering in Gaza. And the headlines you read have immense power to shape how you understand the news, which is why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEagle 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting from across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are unreported by either side of the political spectrum, like the story of the Trump administration considering criminal referrals of USAID employees on fraud charges. This story was a blind spot for left-leaning news media, representing only about 10% of all sources that covered it. It's analysis like this that helps explain why we often talk past each other and why some people seem hyper-focused on what seems like nonsense or fake news. But that's why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off their Ground News Vantage subscription by scanning the code that's on screen right now or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the news media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more LegalEagle, or I'll see you in court. Here in Washington, D.C., since we're not a state, crimes get prosecuted by the U.S. Attorney's Office for the Federal District for the District of Columbia. Terrible name, I know. But even worse than that, right now, the interim head of that office is possibly the biggest POS in the country. Yes, Donald Trump rewarded his #1 sycophant, Ed Martin, with a prestigious job leading the most powerful prosecutor's office in the country, a job for which he has zero experience and is perhaps even less qualified if having the basic standard of ethics is an important qualification. And due to our little quirk of federalism, the U.S. Attorney's Office for D.C. is the only district with the authority to prosecute both federal and local crimes, granting it incredible power. And due to its proximity to the seat of government, the U.S. Attorney's Office in D.C. often deals with the highest profile cases and those involving the people actually governing our country. And historically, this was the office responsible for prosecuting Watergate and the January 6th insurrection. So conservative or liberal, this is where the country needs its best lawyers. But now President Trump has nominated Ed Martin, someone who is both a terrible lawyer and a terrible person, to be the permanent head of that office. Chaos lawyer Liz Dye is going to break it down for you because I just can't even.
Thanks, Devin. In his short time leading the U.S. Attorney's Office in D.C., Ed Martin has made quite a name for himself. It's not every lawyer who could mess up the First Amendment, basic criminal procedure, and the role of the Department of Justice all in one tweet. Whether he's slobbering over Elon Musk, threatening random Democrats, or attacking his own staff, the new U.S. Attorney for D.C. is making a big impression. But okay, let's start at the beginning. Who the is Ed Martin? Martin is a Missouri lawyer who made several unsuccessful runs for office and was eventually appointed chief of staff to Republican Governor Matt Blunt in 2005. His tenure was rocky, to say the least. The trouble started in 2007 with a request by the Springfield News leader for Martin's emails under the state's Sunshine Laws. That's the state equivalent of the Freedom of Information Act. Martin refused to turn them over, and that put him crosswise with the governor's deputy counsel, Scott Eckersley, who said that actually those emails were public records and they had to disclose them by statute. Martin fired Eckersley, which set off a wild chain of lawsuits, and by the time the smoke cleared, the state had paid Eckersley $500,000 plus another $1.3 million to outside lawyers to deal with all the litigation. When the governor's office finally produced Martin's emails to the press, it turned out that he had been using his office to slime State Attorney General Jay Nixon, the Democrat who was planning a challenge against Blunt in the 2008 election, as well as a Republican judge named Patricia Breckenridge. A state investigation later concluded that Martin had illegally deleted emails, and Blunt decided not to run for office again. After that, Martin bounced around various conservative organizations, including the Missouri Club for Growth and the Missouri Roundtable for Life. He also chaired the Missouri Republican Party through 2012, a year in which Democrats swept races for governor, secretary of state, attorney general, treasurer, and U.S. Senate. Following that resounding victory, Martin decamped to the Eagle Forum, the powerful conservative group founded by famed anti-feminist Phyllis Schlafly. Schlafly, who was herself a lawyer with degrees from Washington University and Harvard, made her name campaigning against the Equal Rights Amendment that would have enshrined women's equality in the Constitution. Martin's tenure as president of Schlafly's organization was marked by acrimony, lawsuits, and accusations of impropriety. It's kind of his thing. Matters came to a head in 2015 when Martin engineered an endorsement of then-candidate Donald Trump over Senator Ted Cruz. Apparently, he and Schlafly thought Cruz and his wife Heidi Cruz were big-time feminists. The board tried to remove Martin, and a lawsuit was filed pitting one of Schlafly's children against the other. Schlafly was by then 91 years old, but she followed Martin to a new competing outfit known as the Phyllis Schlafly Eagles, none of which would suggest that Martin has the managerial skills to run one of the largest U.S. attorney's offices in the country, not to mention prosecutorial skills since he never worked as a state or federal prosecutor. In 2018, Martin moved from Missouri to Virginia. Once again, he ran for local office, and once again, the citizen said, hard pass. But Martin was still head of the off-brand Eagles, and he had his law practice. Plus, he remained active in conservative causes, and look, we all can see where this is going. In 2020 and 2021, Martin championed the lie that Trump had won the election. On January 5th, he spoke at a pre-riot rally and led the crowd in chants of Stop the Steal. On January 6th, he participated in the march on the Capitol. At 2:53 p.m., he posted, "I'm at the Capitol right now, and I was at the POTUS speech earlier. Rowdy crowd, but nothing out of hand. Ignore the hashtag fake news." 4 minutes later, he said, "Like Mardi Gras in D.C. today. Love, faith, and joy. Ignore hashtag fake news." At 2:57 p.m. on January 6th, rioters were inside both chambers of Congress. The members had all been evacuated. Ashley Babbitt had just been shot. Vice President Pence was in hiding, and the crowd was demanding that the police hand over Pence and then Speaker Nancy Pelosi so they could hang them. So I don't know what kind of Mardi Gras parades Ed Martin is going to, but it really doesn't sound like any laissez-les-bon temps roulés I've ever been at. Later, he represented multiple January 6 defendants, including William Crestman, a member of the Proud Boys militia who pled guilty in 2023 and admitted that he had menaced Capitol Police with a pickaxe handle. Martin served on the board of Patriot Freedom Project, which advocated for the January 6 defendants. Here he is on a podcast called The Tea Party Power Hour, explaining that the people who prosecuted the January 6 defendants should go to jail.
And there needs to be accountability. People say, I don't want to ask for revenge. I'm not asking for revenge. America operates on accountability, however. And if you do something wrong to people, you don't get to say, oh, no, don't be mean to me now that you're in charge. No, we'll hold them accountable. And one of the reasons I think that we should fear for this election in the fall is because there's hundreds of Democrats and some Republicans, Liz Cheney, they know they're going to jail. If we get real accountability, they broke laws, not because I don't like them. I'm a conservative. I'm a constitutionalist. I don't care what your opinion is.
And here he is explaining that he thinks the January 6 defendants should get reparations.
To get to the bottom of it and hold these bastards accountable, and we can do it. But by the way, I'm for reparations. I finally come around to reparations. I believe that everyone that has been targeted on January 6th, they should get a pot of money, like the asbestos money that we got for victims of asbestos, like the other things, and they should be able to go access it.
And so it's not a big surprise that Martin's first priority after Trump appointed him to lead the D.C. Attorney's Office was revenge. He began by firing 30 prosecutors who'd worked on the January 6 cases. Other senior officials with years of experience were demoted to handling low-level misdemeanor cases, a blatant effort to humiliate them and force them to quit. And he launched what he called Project 1512. That one requires a little bit of unpacking. See, a bunch of the January 6 defendants were charged with corruptly obstructing an official proceeding under 18 U.S.C. Section 1512C. That law says that whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes an official proceeding, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years, or both. Now, some of the January 6 defendants argued that or should be read as and. So they said it wasn't enough that they obstructed the certification of Biden's 2020 electoral victory by making the senators and representatives flee for their lives. They argued that you had to also alter, destroy, mutilate, or conceal a record or document or other object to be guilty of obstruction of Congress under the title. And every judge who looked at it said, what are you talking about? The law says or, except for one Trump appointee who said or, seems like it means and to me, And the D.C. Circuit said, what are you even talking about? Or means or. But then the Supreme Court said, and, we're reading it as and. And because they're the ones who get to decide, we all have to pretend now that it says and. And thanks, Chief Justice Roberts. Anyway, Martin is now launching his Project 1512 to examine the 1512 charges, which he calls the great failure of the DOJ. Funny enough, Martin's own client, William Crestman, pled guilty to a 1512 charge. Less funny is that Martin appears to have switched sides in the case of another client, Joseph Padilla. Here he is on January 21 informing the court that the government is dropping the charges after Trump pardoned all the January 6 defendants. And here he is on February 5th asking the court to let him withdraw as Padilla's lawyer. That means that he was both the prosecutor and the defense attorney in the same case, a wild breach of ethics in every jurisdiction. Reuters reports that Martin said he'd stopped all involvement in the cases more than a year and a half ago, that he'd handled them pro bono, and said that he was under the impression that I was off the cases. But as every lawyer knows, once you've entered your appearance, you're not off the case until the court says so, or the case is dismissed. Oh, and by the way, when Martin tried to withdraw his appearance after the fact, the court said he couldn't do it because he'd failed to renew his membership with the federal court in D.C. and wasn't a lawyer in good standing. And while Ed Martin says that Crestman and Padilla were just doing Mardi Gras parades at the Capitol on January 6th, he's pretty sure that other people were doing real violence with words.
Now, okay, sure, Ed Martin is a terrible lawyer, but if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
On March 4th, 2020, after the Supreme Court heard arguments in a major abortion case, Senator Chuck Schumer made a poorly worded reference to two conservative Supreme Court justices at a rally.
I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price.
The comment was injudicious, and Schumer apologized the next day. It certainly didn't hinder the Supreme Court, which went on to overturn Roe v. Wade in 2022. But Martin has been trying to make Schumer's comment into a crime, launching what he called Operation Whirlwind shortly after taking office. We will stop the storm of threats against officials at all levels, he told his underlings. Then he fired off a series of threatening emails to the senator requesting that he, quote, clarify his comments from 5 years ago. He said, time is of the essence. You have now received 3 letters as well as public discussion. Your cooperation is more important than ever to complete this inquiry before any action is taken. I remind you, no one is above the law. Now, maybe Martin is just confused. After all, he was never a prosecutor before, and he fired everyone with seniority who might walk him through Criminal Investigations 101. To be clear, that is not how criminal investigations go. If prosecutors actually think a crime has been committed, they do stuff like interview witnesses, go to a grand jury, file a criminal information. They do not send pissy emails and have public discussion. And not for nothing, but the statute of limitations on incitement or whatever else Martin is pretending he's going to charge Schumer with is 5 years. So that whirlwind has whirled. And Schumer isn't the only official Martin is publicly discussing. Representative Robert Garcia said on CNN,
and what the American public want is for us to bring actual weapons to this bar fight. This is an actual fight for democracy.
Martin fired off another nastygram saying, this sounds to some like a threat to Mr. Musk, an appointed representative of President Donald Trump, who you call a dick, and government staff who work for him. It is not a crime to call Elon Musk a dick. Whew. And it's not a threat to Musk to talk about bringing weapons to a metaphorical bar fight, which is why we're talking about a pointless letter from the U.S. attorney and not a grand jury. According to the New York Times, Martin tried to get the IRL prosecutors at Main Justice to whirl with him, and he got blown off. And it wasn't for the last time. Remember that video that Devin put out about EPA Administrator Lee Zeldin trying to recoup $20 billion of gold bars from Democratic activist Stacey Abrams? It's a banger. But briefly, the right-wing smear shop Project Veritas secretly recorded a staffer at the Biden EPA talking about the rush to disperse clean energy funds after the election out of fear that Trump would try to claw them back, which seems pretty prescient since the first thing Trump did was order a blanket freeze on all federal disbursements, and specifically clean energy funds under the Infrastructure and Inflation Reduction Acts, which is, again, totally illegal, as we've said in about 10 videos. Anyway, the staffer made an offhand comment about throwing gold bars off the Titanic, and at another point in the video talked about green banking. That was a reference to greenhouse gas reduction funds to be parked with nonprofits and doled out as loans or grants to finance environmental projects in partnership with private businesses and nonprofits. Congress allocated the money for this very purpose under the 2022 Inflation Reduction Act, which is, again, a law. Project Veritas edited the video to make it seem like the staffer was talking about green bank funds when he made the gold bars comments, and Zeldin seized on that as evidence that there was somehow fraud in the disbursement of the funds.
Shockingly, roughly $20 billion of your tax dollars were parked at an outside financial institution by the Biden EPA. This scheme was the first of its kind in EPA history, and it was purposefully designed to obligate all of the money in a rush job with reduced oversight.
The whole thing was a concocted scandal, but Zeldin didn't care, and neither did Ed Martin. Over the long President's Day weekend, Martin tried to gin up a federal investigation of the gold bars. To be fair, the directive came from Maine Justice, specifically Emil Bovee, Trump's personal lawyer who was then occupying the number 2 spot at the Justice Department. Bovee is now the number 3 guy since Todd Blanche, Trump's other personal lawyer, got confirmed as the Deputy Attorney General. Anyway, Bovee said he wanted a grand jury to investigate the non-existent gold bars, and so Martin tasked Denise Chung, the head of the criminal division in his shop, with making it happen. Chung, a 24-year DOJ veteran, said that there was no probable cause to open a criminal investigation or to seize those funds. After spending the weekend going back and forth with the FBI, Chung said that the best she could do ethically was draft a letter for the FBI to send to Citibank, which was holding the funds. That letter said there may be conduct that constitutes potential violations of 18 U.S.C. Section 371, conspiracy to defraud the United States, and 18 U.S.C. Section 1343, wire fraud, that merits additional investigation, and recommended freezing the money so the grant recipients couldn't get paid out. But Martin demanded that Chung write a second letter under her own name, ordering Citibank not to release the funds pursuant to a criminal investigation being run out of the U.S. Attorney's Office in D.C., which she could not ethically do, so Chung resigned. Martin eventually sent out the letter and followed up by trying to get a seizure warrant. But according to the Washington Post, a federal magistrate judge rejected the warrant application because, as Chung had repeatedly told him, there was no probable cause. It's hard to overstate how weird this all is. First, the U.S. Attorney for D.C. is a really big job. Martin presenting this warrant himself to a federal judge is like having the mayor of Cleveland out writing parking tickets. It's way below his pay grade. Second, what did Martin think was going to happen there? He's never been a criminal prosecutor. The most experienced criminal prosecutor in his office said, hey, there's no there there. Did he think he was just going to dummy something up and get a judge to go for it? But funny enough, there was one politician he did not want to go after. On Wednesday, February 26th, the Metropolitan Police Department in Washington, D.C. responded to a report of a domestic disturbance. At the scene, they found a woman claiming to be the domestic partner of Florida Congressman Corey Mills. NBC's D.C. affiliate says that there were 3 police reports filed. According to the first report, the woman showed the police bruises on her arms along with her broken phone and allegedly let officers hear Mills instruct her to lie about the origin of her bruises, presumably by putting the call on speaker. Later, Mills made contact with the police and admitted that the situation escalated from verbal to physical, but it was severe enough to create bruising. The woman, who was, by the way, not Mills' wife, later retracted her statement, attributing her bruises to eczema and claiming that she was just agitated because of jet lag. Mills' office put out a statement saying law enforcement was asked to resolve a private matter at Congressman Mills' residence. Congressman Mills vehemently denies any wrongdoing whatsoever and is confident any investigation will clear this matter quickly. But many domestic violence victims retract their statements out of fear or shame, and police departments often have internal protocols requiring officers to take an alleged offender into custody if there's probable cause to believe that an assault took place. The police's failure to do that is under internal investigation, but here's where Martin comes in, because D.C. is not a state, and so the U.S. Attorney's Office in D.C. acts as the local prosecutor. It's called the Superior Court Division, and it's where Martin banished some of the more senior January 6 prosecutors, sticking them on purse snatchings and bar fights in an attempt to get them to quit. Here, the D.C. police requested a warrant to arrest Mills, a Republican, and Martin's office said no. Hey, remember that time in 2018 when Donald Trump yelled at his own Attorney General, Jeff Sessions, on Twitter because 2 very popular Republican congressmen got indicted just ahead of the midterms? That was a reference to Duncan Hunter, a representative from California who spent more than $200,000 of campaign funds on personal expenses, including family vacations, Uber rides to his girlfriend's houses, and the gaming platform Steam. He blamed that last one on his 12-year-old son. Trump was also mad about Chris Collins, a New York congressman indicted for insider trading. Funny enough, Collins was at a White House picnic on June 22, 2017, when he called up his son and told him to dump shares of a biotech company after a failed clinical trial. Both men pled guilty and both were eventually pardoned. But this time around, the Trump Justice Department is not taking any chances. So Martin will not be charging Mills. On the other hand, he does spend a lot of time tweeting at, quote, thugs. Here he is under the hashtag MarchBadness tweeting, "Hey, thugs with guns, you hear that? Yup, we coming." Oh my God, I just cringed so hard I think I pulled something. But maybe we're being too hard on Ed Martin. Maybe he's not corrupt, he just doesn't understand the law or punctuation. Here's a tweet from February 24th in which he describes the Justice Department as President Trump's lawyers. In fact, the Justice Department is supposed to be independent of the White House. Those lawyers may carry out the president's priorities, but they do not represent the president, and they certainly aren't responsible for protecting his leadership. And I'm not sure what Martin intends to do as a U.S. attorney to stand against the Associated Press for its refusal to call the Gulf of Mexico the Gulf of America. That would appear to be an issue of basic free speech under the First Amendment, and it's not the only issue. Here's Martin promising to use his office to pursue lawbreakers or even people who have acted unethically to the end of the earth. Martin appears to have been promising to go after anyone who docks the DOJ employees currently racing to unplug the federal bureaucracy, and that's not a crime. Here he is threatening the law firm Covington and Burling for daring to provide pro bono legal advice to former special counsel Jack Smith. Here he is threatening 4 former national security officials from his official government account based on a rando tweet. No, Susan Rice, Victoria Nuland, Anthony Blinken, and Alex Vindman weren't whispering in Ukrainian President Volodymyr Zelensky's ear. That's internet gibberish, which Martin didn't even bother to verify. And here he is announcing that he'll be discriminating against students and graduates from Georgetown Law School because he's heard they teach DEI there. He said, "It has come to my attention reliably that Georgetown Law School continues to teach and promote DEI. This is unacceptable. I have begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? Second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it?" It should not need to be said that the federal government does not get to dictate curriculum to private educational institutions, but apparently it did need to be said, and so the law school's Dean William Traynor said it. He said, "The First Amendment guarantees that the government cannot direct what Georgetown and its faculty teach and how to teach it. The Supreme Court has continually affirmed that among the freedoms central to a university's First Amendment rights are its ability to determine on academic grounds who may teach, what to teach, and how to teach it." And he reminded Martin that the Trump administration just had to walk back its threats to defund or launch civil rights actions against schools for woke curriculum. The dean noted that the government withholding a benefit to retaliate against disfavored speech is a classic First Amendment violation, and it's not close. Given the First Amendment's protection of a university's freedom to determine its own curriculum and how to deliver it, the constitutional violation behind this threat is clear, as is the attack on the university's mission as a Jesuit and Catholic institution. So much of what Martin has done is wildly inappropriate, as the Democrats on the Senate Judiciary noted in a letter to the D.C. Bar Council accusing Martin of violating the D.C. Rules of Professional Conduct and the Justice Department's own guidelines about 6 ways from Sunday. For instance, Rule 3.8 says that a prosecutor shall not make extrajudicial comments which serve to heighten condemnation of the accused, both because it's inappropriate and because it can poison the jury pool. The Justice Manual says that officials will not confirm the existence of or otherwise comment about ongoing investigations and should take care to avoid implying that a referral from the public will lead to an investigation, and to stress that there is a distinction between reviewing a request and opening an investigation. So when the Department of Homeland Security reposts a conspiracy theory by the Doge Bros and tags Ed Martin, it is not appropriate for him to respond, "Duly noted, we are on it." But I guess Martin isn't too pressed about rules, and neither is Trump, who first installed Martin on an interim basis and then nominated him for a full term. Martin responded that it was the honor of his lifetime to accept the nomination and pledged to work as hard as Trump does for America, even though no one outworks him. Well, he could start by reacquainting himself with the rules of prosecutorial ethics, maybe followed by a refresher on criminal procedure.
Thanks, Liz. And to add a cherry on top of the crap sundae that is Ed Martin, The Guardian reports that Ed Martin has a history of making derogatory and racist comments. The Guardian reports, quote, Martin's rhetoric includes falsely claiming Kamala Harris as self-identified as black and calling her the new Rachel Dolezal, claiming Planned Parenthood targets black communities for abortions, claiming that the Supreme Court Justice Sonia Sotomayor made racist comments to white males about their own identity, and invoking false claims about Dr. Martin Luther King Jr. to affirm support for the Republican Party and the Tea Party movement. Now, Ed Martin and the Trump administration are showing no signs of restraint in ruining the lives of anyone who criticizes them or their regime. So now might be a good time to remove your personal information from the internet. And luckily, today's sponsor, Incogni, can help. And you can use my link in the description of the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It might be why you're getting so many spam calls lately, or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen right now or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word. After that, click on this link over here for more LegalEagle, or I'll see you in court. Yes, Trump finally won a popular vote. 12 citizens of New York unanimously found former President Donald Trump guilty of all 34 felony counts. He reacted about as you would expect.
This was a rigged trial by a conflicted judge who was corrupt.
It's really unfortunate that Trump has been a victim of a rigged election, rigged impeachment, rigged federal judicial system, rigged state civil judicial system, and now a rigged state criminal judicial system as well.
Remember, folks, it's a rigged system.
Yeah, cry more, Donnie. Chaos lawyer and reluctant Trump whisperer Liz Dye has the details.
Thanks, Devin. Well, it finally happened. For the first time in our nation's history, an American president was found guilty of a felony in a court of law. Although if you ask the future felon himself, that was inevitable.
Mother Teresa could not beat these charges.
Well, yes, if Mother Teresa had gotten her fixer to pay a porn star to keep quiet in the run-up to an election, then covered up the payment through a series of false invoices and checks, she too would probably have been found guilty of 34 felonies. But if Mother Teresa ever did do any of that, she managed to keep it on the down low. Trump, however, is not a keeping it on the down low kind of guy. At the celebrity golf tournament in 2006, where the encounter allegedly took place, he managed to get his picture taken with Stormy Daniels, the adult film actress who had been sent there to represent her production company, Wicked Pictures. And he reportedly boasted about their brief sexual encounter the next day. But 10 years later, when he decided to run for president, he was decidedly more circumspect. Trump, whose notorious philandering had been a subject of the New York tabloids for decades, suddenly had to sell himself to evangelicals as a faithful family man who just so happened to have 5 children by 3 wives, and to have appeared in a pornographic video, and to have bragged about wandering into the changing room while beauty pageant contestants were getting dressed. And so he enlisted his longtime friend David Pecker, the owner of the National Enquirer, to burnish his image. Pecker, who was the first witness at the trial, testified that just days after Trump announced his candidacy, he was summoned to a meeting at Trump Tower where Pecker promised to help Trump's campaign by publishing positive stories about Trump, negative stories about his opponents, and alerting him through Michael Cohen when Pecker came across damaging information, particularly regarding women. Pecker brought up 2 stories, including one from Playboy model Karen McDougal, who was paid $150,000 for her account of a relationship with Trump a decade earlier. Pecker testified that he'd buried stories for other celebrities before and even for politicians. But his lawyers convinced him that selling McDougal's story to Trump might look like a campaign finance violation, so he refused to go through with it. Then, Stormy Daniels came forward, and Pecker testified that he refused to pay her out of fear that the association with an adult film star would upset Walmart, the National Enquirer's biggest distributor. And even after Cohen threatened that the boss would be furious if he didn't do the deal, Pecker wouldn't budge. So Cohen negotiated to pay Daniels $130,000 to sign a non-disclosure agreement, aka an NDA. Except that Trump kept putting the deal off in hopes that he could delay until after the election and avoid paying her altogether. Then on October 7th, 2016, the Access Hollywood tape dropped, with Trump bragging about grabbing women by the genitals because...
And when you're a star, they let you do it. You can do anything.
Trump's aide Hope Hicks testified that the tape went off like a bomb inside the campaign, knocking a Category 4 hurricane out of the news cycle, at which point Trump told Cohen to make that deal with Daniels happen, and he didn't care how, because Stormy Daniels telling her story in the press would be the end of his presidential campaign. So Cohen borrowed $130,000 against his house and put together an NDA for David Dennison and Peggy Peterson to sign, where they all agreed never to speak about the matter again. And on November 1, the agreement was signed and Trump went on to win the White House. During their opening statement, prosecutors revealed that on election night 2016, Daniels' lawyer Keith Davidson messaged Dylan Howard, then the editor-in-chief of the National Enquirer, asking, "What have we done?" Howard replied, "Oh my God." Howard texted a family member speculating that maybe Trump would pardon him for electoral fraud, which strongly suggests that everyone involved in the Daniels payoff thought that their schemes had put Trump in the White House, and they strongly suspected that what they had done was against the law. Michael Cohen, who had hoped for a job in the administration, perhaps even as White House chief of staff, soon found out that he was going to be fobbed off with the title personal attorney to the president and very little else. And while that honorific allowed him to pitch himself as a sort of lobbyist, it didn't come with a paycheck. In fact, the Trump Organization actually cut his Christmas bonus that year and kicked him off the payroll in January of 2017. By December, Cohen was furious that he hadn't been repaid the $130,000, and he even prevailed upon Pecker to intervene with Trump on his behalf, which Pecker did, and according to his testimony, Trump said, "Don't worry about it, I'll take care of it." And the way that he took care of it was through a series of monthly checks for $35,000, supposedly paying Cohen for legal expenses.
I don't know, this all seems really complicated. Legal fees, reimbursements, taxes. If only there was someone who were really good at explainers.
So at the trial, Trump Org Comptroller Jeffrey McConney was shown Exhibit 35, a bank ledger documenting that Michael Cohen had wired $130,000 through an LLC to Stormy Daniels' lawyer, Keith Davidson. So that was the payment to Daniels, $130,000. On the ledger, though, there were also handwritten notes, presumably by Cohen, adding $50,000 to the tally for money paid to a company called Red Finch to rig an online poll that CNBC was running on the most famous businessmen because Trump was frustrated that he was in ninth place. So that brought Cohen's out-of-pocket expenses to $180,000. Now, on the left side, there were notes by Trump Org CFO Alan Weisselberg documenting that they would have to gross up the payment to $360,000 to account for the fact that Cohen would owe taxes because he was calling it income to keep the reimbursement secret. If it were publicly a reimbursement, the money would come into Cohen and then out, and he could call it an expense and wouldn't be taxed on it. But because they were going to be keeping it a secret, he would have to declare that as income. And then on top of that, they added a $60,000 bonus, presumably just because, like, at this point, Cohen knew a lot, so they should keep him happy. So now that's a total of $420,000. And if the payments were going to be paid out in $35,000 increments, that'd be like 12. That'd be 12 equal payments. And that's what there were. This isn't complicated math.
Exhibit 36 was McConney's own notes from the meeting, confirming that the $180,000 would be doubled for taxes and wired monthly from DJT in increments of $35,000. He even included a helpful note that Cohen would be removed from the Trump Organization's payroll in January of 2017, after which Mike was to invoice us that $35,000 a month, which he did. And to top it all off, these notes were on Trump Organization stationery because none of these geniuses had ever heard of the Stringer Bell rule.
Is you taking notes on a criminal fucking conspiracy? What the fuck is you thinking?
At the trial, Trump's lawyer Todd Blanche argued that Cohen had actually been doing legal work in 2017 to earn those monthly payments. In his closing argument, he made the bizarre claim that Cohen secretly paid off Daniels as part of a plot to take advantage of Donald Trump. Quote, "He made a decision to pay that $130,000 to Ms. Daniels. He didn't tell President Trump about it. He wanted to do it because he knew that he could get credit for doing something to supposedly help President Trump at some later time. Whether they won the election or lost the election, he would be able to get that credit." And that might have been persuasive if the prosecutors were simply asking the jury to take Michael Cohen's word for it. After all, Cohen was convicted of tax fraud and lying to Congress. He's hardly a credible character. But it wasn't just Cohen calling it a reimbursement for the hush money payment. David Pecker testified that he had also leaned on Trump to pay Cohen back. And McConney confirmed that he took Cohen off the payroll and routed those invoices through bookkeeping rather than through the legal department. Exhibits 35 and 36 showed that the Trump Organization's bean counters were doubling the debt to cover Cohen's tax liability, and Hope Hicks practically laughed on the witness stand when prosecutors asked if she thought Cohen was the kind of guy to secretly make a $130,000 payment to Stormy Daniels out of the kindness of his heart. She said, "I didn't know Michael to be an especially charitable person or selfless person. He's the kind of person who seeks credit." There's also the fact that Trump tweeted repeatedly that he'd reimbursed Cohen for the Daniels payout. And not for nothing, but Rudy Giuliani, Trump's own lawyer, admitted it on air back in 2018.
So they funneled it through the law firm. Funneled through the law firm, and the president repaid it.
Trump's current lawyer, Todd Blanche, countered by calling Michael Cohen a liar over and over and over again at high decibel. He said, "It's like what people talk about with athletes like Michael Jordan is the GOAT, Tiger Woods is the GOAT, Tom Brady is the GOAT. These athletes are the greatest of all time, the best among their peers. Michael Cohen is the gloat. He's literally the greatest liar of all time."
Stop it. Get some help.
Assistant District Attorney Joshua Steinglass, who delivered the 6-hour closing argument, said, "Keep something else in mind when the defense goes on and on about how Michael Cohen is immoral, or he's a liar, or he's a thief." Mr. Blanche actually said, "This is not the type of witness you want. We didn't choose Michael Cohen to be our witness. We didn't pick him up at the witness store. The defendant chose Michael Cohen to be his fixer because he was willing to lie and cheat on Mr. Trump's behalf," which is a slightly better joke. Plus, Steinglass had all those exhibits and witnesses to back up what Michael Cohen said.
Well, the jerk store called. They're running out of you.
In the end, it took the jury of 7 men and 5 women less than a day and a half to reach a guilty verdict.
Now, throughout this trial, Trump was represented by Todd Blanche. But if you want a good lawyer, my law firm, the Eagle team, can help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, if you were involved in a car accident, or have dealt with sexual harassment from Trump or anyone else, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below.
Each check, ledger entry, and invoice related to Cohen's monthly payouts was charged as a separate count, which is how Trump got indicted for 34 counts of falsifying business records in the first degree under New York Penal Law Section 17510. But 17510 is a felony charge that derives from first-degree falsifying business records, which is a misdemeanor. So under 17505, it's a misdemeanor to make or cause a false entry in the business records of an enterprise. And under 17510, it's a felony to make a false business record with the intent to commit another crime or to aid or conceal the commission thereof. In plain English, if you create the false business record as part of a criminal scheme, then it becomes a felony. And look, no one in that room believed that Michael Cohen was being paid $35,000 a month for work performed in 2017. The misdemeanor false business records were pretty much a given. So for the purposes of this case, the main thing that prosecutors had to do was come up with another crime that would plus up that misdemeanor false business record to a felony. And in fact, they came up with 3. First, and most obvious, is tax fraud, because everyone understood that the object of this game was to have Cohen file a false tax return claiming that he'd earned $420,000 for work performed when he was actually being reimbursed for what was functionally a loan to the campaign. The second crime was a violation of the Federal Election Campaign Act, or FECA, because in 2016, when Cohen paid $130,000 to Daniels, the maximum an individual could donate to a campaign was about $2,700. And while Cohen didn't write the check to the Trump campaign, he did write it for the benefit of the Trump campaign. And that still counts. So if Cohen had, say, hosted a party for the campaign and paid $10,000 to the caterer, it would still be an excessive campaign contribution, and this is no different. Trump's lawyers tried to argue that Trump wanted to silence Daniels to protect his family from embarrassment, not for political ends. But that was pretty fatally undercut by Pecker's testimony that Trump invited him to a meeting at Trump Tower just days after announcing his candidacy. At the meeting, they cooked up a plan for the National Enquirer to bottle up stories that damaged Trump while attacking his rivals. The whole purpose of this plan was to protect the campaign. Trump never cared about buying Stormy Daniels' silence between 2006 and 2016, and if he'd never run for president, it would have stayed that way forever. And so the prosecutors argued that money Cohen had paid to Daniels was an undeclared and excessive campaign contribution. The third predicate was a violation of New York election law, section 17152, which makes it a crime to conspire to promote or prevent the election of any person to public office by unlawful means. And here's where things get a little wonky, because the prosecutors suggested that the unlawful means were the tax fraud and the campaign finance violation. So in some sense, this thing kind of loops back on itself. Once they defined the crimes, the prosecution had to prove that Trump had the intent to commit them. The judge instructed the jury that a person is guilty of falsifying business records in the first degree when, with intent to defraud that includes an intent to commit another crime or to aid or conceal the commission thereof, that person makes or causes a false entry in the business records of an enterprise. So under New York law, the prosecution had to prove beyond a reasonable doubt that Trump both committed the business records offense and that he intended to commit one of the three other offenses. The prosecution didn't need to show that he committed the other three offenses, though. And it gets even wonkier because the jurors didn't have to agree on which of the three other crimes plussed it up from a misdemeanor under 175.05 to a felony under 175.10. The jury instruction said, in determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following. 1. Violations of the Federal Election Campaign Act, otherwise known as FECA. 2. The falsification of other business records, or 3, violation of tax laws. So, 4 of the 12 jurors could believe that the other crime was tax fraud, 4 could buy the FECA violation, and 4 could be convinced by the nesting doll of the New York State election crime. And that would be fine. In fact, no one will ever know which predicate they accepted, or even if this was an issue at all for the panel, since there was no place on the charge sheet for the jurors to specify which other crime they were basing their verdict on. And it may seem odd, but that's just how New York law works, which Trump's lawyers explicitly acknowledged during the charging conference when they negotiated those jury instructions. Trump wanted the judge to say, you, the jury, must reach unanimous decision regarding whether the people have established unlawful means, and if so, which unlawful means was or were at issue. And Justice Merchan said, do you agree that unanimity is not ordinarily required? To which Trump's lawyer Emile Beauvais replied, certainly, but we think it's important under the circumstances of this case and think it's in your honor's discretion to make clear the record here. In other words, he said, I admit that I'm asking you to make an exception for my client and the decision to do so is within your discretion. But the judge said, what you're asking me to do is change the law, and I'm not going to do that. And that was that. This will not be an issue that gets the case overturned on appeal, but it will be an issue that sucks up a lot of airtime. In fact, it already is. Donald Trump got the ball rolling earlier in the week with a post on Truth Social claiming that the reason the radical, highly conflicted judge Juan Merchan had to come up with 3 fake options for the jury to choose from without requiring them to be unanimous, which is completely un-American and unconstitutional, is because the corrupt Soros-backed DA, Alvin Bragg, couldn't come close to proving that any crime was committed. Soon, all of Trump's MAGA allies were singing from the same hymnal. Senator Marco Rubio tweeted that judge in Trump case in NYC just told jury that they don't have to unanimously agree on which crime was committed as long as they all at least pick one, and that among the crimes they can pick from are ones Trump wasn't even charged with. This is exactly the kind of sham trial used against political opponents of the regime in the old Soviet Union. Simmer down, little Marco. Fox News' John Roberts tweeted that Judge Merchan just told the jury that they do not need unanimity to convict. 4 could agree on one crime, 4 on a different one, and the other 4 on another. He said he would treat 444 as a unanimous verdict. Here's Trump's favorite legal commentator, Jonathan Turley, a professor at George Washington University Law School, explaining on Fox that no one knows what the crime is.
When they were reading those guilty verdicts, the one thing that we didn't know is really what he was found guilty of. Because if you remember, the judge allowed the jury to find guilt on any one of 3 secondary crimes. We weren't told whether the jury found any one of those crimes, whether they found all 3 of those crimes. I'm not too sure we will know that.
That's just not true. Donald Trump was convicted of creating a false business record to cover up an illegal campaign contribution made to influence the outcome of the 2016 presidential election. Unanimity as to the predicate is not required under New York law, as his lawyers acknowledged in open court. But perhaps the former president can be forgiven for his failure to understand the vagaries of New York criminal procedure and precedent. In fact, This whole thing has been a learning experience for him. He was shocked and chagrined to discover that the prosecution, which has the burden of proof, gets the last word. Early in the week, he posted on Truth Social, "Why is the corrupt government allowed to make the final argument in the case against me? Why can't the defense go last? Big advantage, very unfair, witch hunt DJT." After closing arguments, he stood next to his lawyer Todd Blanche and claimed that the prosecutors rigged the case by failing to call important witnesses.
But a lot of key witnesses were not called. Look at your list. Look at the players. And you know who I'm talking about. You can take 5 or 6 of them. Why didn't they call those witnesses? They didn't call them because they would have been on our side.
Blanche said the same thing, but dumber, on CNN.
We never saw Keith Schiller, Alan Weisselberg, some key figures here who got brought up a lot. Why didn't the defense call any of these witnesses?
Well, because we happen to live in America and we don't have the burden of proof. And so there's not... That's not the point. That's a question that is a loaded question that should not be asked of a defense attorney or a defendant. The question that we asked the jury, and they ultimately obviously got passed, is why the prosecution didn't call those witnesses.
As many have noted,
that's not how this works. That's not how any of this works.
I think what Devin's trying to say is that it's an odd complaint because the defense could have called those witnesses. Blanche, whose poker face is second to none, failed to remind his client, or maybe doesn't know, that both sides have subpoena power. So if there were witnesses who should have been called, Trump's own lawyers could have put them on the stand. Then Blanche headed to Fox to take a well-earned victory lap.
Would you have done anything differently? Is there a witness you said, oh, maybe I should have called that witness. Maybe I should have done this?
Yeah, I don't know. I got to think about that, man. Like, we had a team. You know, my team is amazing. You know, the folks that work with us they're brilliant, and the president has a team, and they're brilliant, and we all did the best that we could, and I wouldn't change anything that we did.
So what happens next? Well, first the defense and the state will each file a brief setting out their preferred sentence. Let's go out on a limb here and say that Trump's submission will have a big fat 0 on it. He's going to say that he did nothing wrong, that he's a first-time offender, that he's no danger to the community, that he's running for president, and that there is functionally no way for a probation officer, much less a prison guard, to supervise a man with a Secret Service detail. The prosecutors are going to say, not that. They're going to look at New York Penal Law Section 70, which sets out a maximum term of incarceration for a Class C felony at 4 years, but it gives the judge extremely broad discretion to do whatever he likes. And it seems pretty unlikely that the district attorney just spent 6 weeks in court with the goal of getting the defendant sentenced to probation. We'll just have to wait until June 13th to see what the parties request. The sentencing hearing itself is scheduled for July 11th, as per the request of Trump's lawyers. That did not stop Trump's son, Don Jr., from complaining that prosecutors had scheduled the sentencing 4 days before the GOP convention. They're not even trying to hide election interference. At the hearing, Justice Merchan will consider both sides' briefs, as well as a pre-sentencing report prepared by a probation officer after consultation with the defendant. The judge can consider Trump's behavior during the trial, including his 10 violations of the gag order and his clear lack of remorse. And while an elderly defendant with no criminal record would typically get probation, former prosecutor Diana Florence, who spent 25 years in the Manhattan District Attorney's Office, thinks that Trump stands a good chance of getting a custodial sentence. She told Politico, given the entirety of the facts and the circumstances that came out during the trial, I believe if convicted, a sentence of incarceration is warranted and justified. Once he's sentenced, Trump will have the right to appeal, and hello, of course he's going to appeal. He's already teed up challenges to Justice Merchan's refusal to recuse himself, as well as to a raft of evidentiary rulings and the court's denial of his motion to move the case out of Manhattan. The standard to reverse Justice Merchan will be abuse of discretion, which is a huge uphill battle. But even if Trump loses, those appeals will stretch well into 2025, and while it's technically possible that Justice Merchan could order him incarcerated pending appeal, it's highly unlikely that will happen. The guilty verdict will not stop Trump from running for president, though, and it won't even stop him from casting a ballot in his home state of Florida. Under Florida law, a felony conviction in another state makes a person ineligible to vote in Florida only if the conviction would make the person ineligible to vote in the state where the person was convicted. And under New York law, unless a person is actually incarcerated, they are eligible to vote. #rigged. But if Trump doesn't get his case overturned on appeal, he'll be a convicted felon, and that will have an impact on the pending criminal cases in D.C., Florida, and Georgia. Because you can only cash that first-time offender ticket once. And in both Georgia and the federal system, he'll be ineligible for some downward sentencing departures as a repeat offender. Of course, if Trump gets reelected in November, he probably won't have to worry about any of that. But that is a problem for another day.
Yeah, by all accounts, this was a winnable case for Trump and his lawyers. It was never a given that the New York prosecutors would win this. But what about the performance of the defense attorneys in this case? Well, they didn't exactly nail it.
Nailed it!
One of the biggest mistakes was probably denying that Trump ever had an affair with Stormy Daniels. If Trump had conceded that he had had sex with Daniels, there'd be no reason for her to testify. But he denied it, so the prosecution had to call Daniels as a witness, and she told the jury about her harrowing encounter with Trump, and obviously the jury sympathized with her. Now, the defense also screwed up by attacking anything and everything about the case. Now, that's obviously Trump's personal style, and it might work in business and politics, but it doesn't necessarily work in a courtroom. Former prosecutor Renato Mariotti said in the New York Times, and I think he gets this exactly correct, the defense needed to tell a single story, which they could have, but didn't. Only Cohen was able to make the direct link that Trump personally directed the payments. And the defense could have laser focused on the idea that Trump was in the White House at the time and others like Alan Weisselberg were responsible and that the jury shouldn't believe Cohen. And the defense did attack Cohen, but they attacked every issue and witness with the same over-the-top histrionics and lost credibility and focus, which is not a good trial strategy. And they also probably made a mistake by not seeking a jury instruction on lesser included offenses that would have allowed the jury to find him guilty of misdemeanors rather than felonies. But you never guess any of this from the reporting on the case. What's interesting is that the Trump conviction has been covered extensively by over 600 news outlets, 37% of the reporting coming from the left and 21% on the right. But if you compare the headlines, you see some interesting frames emerge. On the left, you have outlets focusing on Trump's intent to influence the 2016 election, emphasizing political implications and the legal mechanism behind the charges. On the right, outlets tend to detail Trump's ongoing assertions of political persecution and interference. Now, usually these differences are subtle, but here they're pretty obvious, and they have a big role in how readers perceive the story. The first reports might relish the political victory, while the second set may leave open the question of the verdict's validity. And all this analysis is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. This can be especially helpful when reading stories from sources you've never heard of, which could be run by total nutjobs. And with the Bias Insights tool, it gives me a quick overview of the differences between left and right coverage. I also love their blind spot feature that shows you stories that are being underreported by either side of the political spectrum. It helps explain why we often talk past each other, and some people seem hyper-focused on what seems like nonsense, often because some random blog post went viral among certain people. But Ground News is my favorite way to get the news, and as a legal eaglet, you can save 40% off of the Ground News Vantage subscription by clicking on the link that's on screen or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed, and by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below for 40% off a subscription. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.